Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor at Faculty of Law, University of Delhi. Quasi-contracts. First is difference between contract and quasi-contract. So we have already discussed about the what is a quasi-contract, what is the rationale behind a quasi-contract, that is theory of unjust enrichment. We have also gone through various provisions pertaining to quasi-contract, that is from section 68 to 72. Now, before concluding, let's see what is the difference between contract and quasi-contract, after which we will be going through the remedy available in case of quasi-contract. Quasi-contract is not a contract at all because the essential factors for the formation of contract are absent. Offer, acceptance, consideration, capacity to contract, free consent, all these things. All these components or all these things which are essentials of a valid contract, they are missing in case of a quasi-contract, right. It is a statutory requirement because see, we can't call it a contract, right, but still it is the statute, the Indian Contract Act is laying down that incorporating such a provision and providing remedy in case of relations which are obligations which are resembling those created by contract. Quasi-contract is based more on principles of natural law such as moral conscience, justice, honesty, duty towards another human being, etc. The main point of difference between contract and quasi-contract is that in case of latter, that is quasi-contract, there is no exchange of offer, acceptance or consideration between two or more parties, still it is legally enforceable. So, it is like similar to the point which we had just discussed above. So, therein we said it is a statutory requirement because law is asking you to do that. Still it is legally enforceable. It is legally enforceable because your right has been infringed, even if no valid contract, but right has been infringed. The last thing is the remedy in quasi-contract. So, section 73, like it provides damages in case of breach of contract, provides similar remedy in case of quasi-contract also, which says when an obligation resembling those created by contract has been incurred and has not been discharged, we are referring to quasi-contracts here, and this is part of section 73 only. Any person injured by the failure to discharge it is entitled to receive the same compensation from party in default if such person had contracted to discharge it and had broken his contract. That means if you are not reimbursing, if you are not repaying, returning, then that the other person, the affected party, has the right to approach the court and claim compensation rightfully. Thank you, friends.